Hi everyone, my name is Causal Link. I'm a solicitor in our commercial litigation unit. So I deal with contentious matters, disputes which commonly arise under contract law, so under commercial and construction contracts largely. So what I'm going to look at today is the topic of force majeure in commercial and construction contracts. So like the other topics we're looking at today, it's very topical with the coronavirus pandemic. So what we've seen over the last month is the government putting a bar on all non-essential work, which is having a profound effect, obviously, on both commercial and construction contracts. So in terms of non-essential work then, what this means in the construction sector is really any work or essential health-related work dealing with the coronavirus crisis. It also bars anything that's not repair and construction of critical road and utility infrastructure, or delivery of emergency services to businesses and homes. So anything else really in the construction sector has been barred for the time being. So as I said, this is having a profound impact on contracts and mostly contractors who ordinarily would be subject to LDs and penalties for non-performance of their contractual obligations. And also for delay to the contract. So contractors are finding themselves unable to meet deadlines and to perform the obligations that they have under the contract. So we're seeing a surge in requests for legal advice from contractors over the last number of weeks who are coming to us really looking to find out what they can do to prevent these claims and to mitigate LDs and penalties at the end of the contract for being unable to meet deadlines and for being unable to comply with their contractual obligations, really. Now, one clause under a lot of these common contracts that we've seen and is becoming increasingly topical is the force majeure clause. So force majeure clauses are standard boilerplate clauses that would arise in most contracts. What force majeure means, for those who doesn't know, it translates as superior force. It means an act of God, and typically it's the type of clause that would cover unlikely events such as warfare or natural disasters. So we've had people coming and looking to see if their force majeure clause can extend to this type of event, so pandemics and diseases. Now really what the answer is that it has to, the force majeure clause is what's known as a creature of contract. So it has to actually arise in the contract. It can't be implied into a contract. So the Irish courts won't put one in there or imply one into a contract if it doesn't actually exist. The next thing is that the wording of the clause itself must provide for pandemic or disease of this nature. So if the force majeure clause is limited to specific events which doesn't include disease or pandemics or anything similar, then the courts will be reluctant to imply one in there from what we've seen before. Now, what may arise is that there's a non-exhaustive list of what constitutes a force majeure event, and in those cases there may be scope to argue that pandemic and disease can be covered because it's such an unlikely event outside of both parties' control that it may apply. So the key question then, can it be successfully relied on in relation to COVID? So obviously, as Michael said, this is an event without precedent. There's no precedent there to say yes or no one way or another. So the answer is that potentially it could apply. But it's subject to a number of considerations legally. So the first and foremost then, as I've mentioned, is that it's a creature of contract. It must actually be in the contract itself, and it must either be a non-exhaustive list of force majeure events or else it must be expressly provided for. So secondly then is the causal link. So what a contractor would have to prove is that the coronavirus crisis is what actually led to the delay or the non-performance. You can't look to rely on the coronavirus crisis to justify a delay that would have arisen anyway. It has to actually be caused by the pandemic itself. Another key factor then is mitigation. So contractors should be taking steps to mitigate delays and mitigate the non-performance insofar as possible. What I would say also is to keep records in terms of mitigation, the steps that a contractor has taken to actually prevent the delays and to prevent the non-performance. And finally then is compliance with notification requirements under the contract. So the contract would usually say that where there's a force majeure clause or another type of clause, which I'll look at in a minute, where those clauses operate under the contract, there are certain conditions that need to be complied with in order for them to operate. So notifications to the employer and to the main contractor. If you're a subcontractor, there'll be certain requirements that have to be met. So it's crucial that you look at the contract itself to see what it says and to see what the requirements are. Just to note that previously with force majeure clauses, while they're very uncommon, they're not often relied on, but the courts, and there's precedent in the UK that says that the courts will adopt a very narrow interpretation. So the courts will look at the words themselves rather than trying to imply an interpretation of the parties into the contract. Now that being said, we're in a period of uncharted waters, and it certainly doesn't sit well with me that the courts could punish a contractor for complying with government mandate. But that being said, the terms of the contract will apply and the courts will be reluctant to go beyond the scope. So what we're seeing then is a call from the Construction Industry Federation of Ireland to Europe, to the FEIC in Europe, to actually declare the coronavirus pandemic as a force majeure event within Europe. So if this was to happen, it would obviously assist courts, judges and other arbiters like conciliators and mediators to actually say that this is a force majeure event under the contract, and to allow these force majeure clauses to be relied upon. So as matters stand then, it's really uncertain as to whether you can rely on a force majeure clause successfully. I think certainly you have to look at the contract, see what it says. First of all, see if there is a clause in there, see what the requirements are of that clause in terms of notification, and keep your records in terms of mitigation then, and to prove a causal link. Now, where a force majeure clause isn't present, there are other potential options for contractors that are in difficulty, or other parties who are in difficulty under their contract in complying with the requirements. So one of those then is the Doctrine of Frustration. So this is a common law doctrine under contract law, that where a contract becomes frustrated, so where the parties can't comply with the requirements of the contract or their obligations, that they can walk away from the contract because it has become frustrated. Now, like force majeure clauses, and even more so, the courts have a very high threshold, I suppose, in applying the Doctrine of Frustration. Mainly because the consequence of applying that doctrine is that all parties' obligations under the contract are discharged and the contract is essentially no longer in existence. So I'd be reluctant to advise a client to rely on the Doctrine of Frustration solely, and it's much better to actually have a clause in the contract that you can point to justify delay or non-performance. Another example of a clause then, which may apply here, is change of law clauses. So they're less common than force majeure clauses, but a change of law clause in some contracts will tell the parties what to do where the law changes when the contract is in existence. Now, in terms of law, it would often be limited to legislation, but in some instances it can also include regulatory guidance or government advice. So obviously with the coronavirus crisis, the government mandate is what has caused these delay in non-performance. So change of law clauses may entitle you to an extension of time in some instances, depending on what they say. And lastly then, event clauses. So an example of this is in the public works contracts. So delay event clauses are in there. So there's a schedule which lists various delay events and what constitutes a delay event. So where the particular event that causes the delay or non-performance falls within one of those definitions, and there's one in there that would potentially cover coronavirus. It says that provided various conditions are complied with, that you will be entitled to an extension of time. So to summarise then, it's crucial that any entity or party to a contract which is affected by COVID reviews the contract and the specific wording, and not only the force majeure clause, but also other clauses in there that set out the notification requirements. So is there a force majeure clause? If not, are there any other clauses like the change of law clause, or an event clause that might apply here to allow you an extension of time. What are the preconditions for compliance with that clause? And then in terms of mitigation, causal link, just keep your records, and if necessary, seek legal advice. So that's it for me, a whistle-stop tour of the force majeure clause and its potential application, potential other remedies under commercial and construction contracts that can be relied upon, and as with Mike and Shane, I'm happy to take questions at the end. Thank you.